When your trial begins, it marks the formal start of the courtroom process to decide if you are guilty or not guilty. After your case moves past preliminary hearings and arraignments, the trial is scheduled. This can take several months from the time of arrest, sometimes up to a year or more due to court schedules and delays. At the trial start, the judge will explain the rules and procedures everyone must follow. You will be reminded of your rights, including the right to remain silent and the right to have an attorney. The prosecution and defense then prepare to present their cases. If you are in jail, you will be brought to court for the trial. The trial date is important because it sets the timeline for your case resolution. Remember, most criminal cases do not go to trial but are settled earlier with plea deals. However, if your case does go to trial, it is important to be ready and understand that this is your chance to defend yourself and present evidence through your lawyer. The trial is a serious step, and being prepared with your attorney is key to the best possible outcome. Jury selection. Jury selection is one of the first important steps in a trial. The purpose is to choose a group of impartial people who will listen to the evidence and decide your case fairly. Both the defense and prosecution get to question potential jurors to find out if they have any biases or reasons they might not be fair. The judge oversees this process and makes sure it is done correctly. Lawyers can remove certain jurors if they believe they cannot be fair, but they have a limited number of these challenges. It's important that the jury is made up of people who can objectively weigh the facts without prejudice. The selected jurors take an oath to deliver a verdict based only on the evidence presented in court and the law explained by the judge. This step is crucial because the jury's decision will decide your fate. Being calm and respectful during jury selection is important. Your lawyer will guide you on how to behave and what to expect, so you don't accidentally harm your case before it even begins. Opening statements. Opening statements are the first chance for both the prosecution and the defense to speak directly to the jury. During this time, each side explains what they believe the evidence will show and what story they plan to prove. It's not a time to argue or present evidence yet, but to give the jury a clear idea of what to expect. The prosecution goes first because they have the burden of proving the defendant's guilt beyond a reasonable doubt. They will outline the crimes they say were committed and the key evidence they will present. After that, the defense will make their opening statement, often focusing on creating doubt or explaining why the prosecution's case is weak. Opening statements are important because they set the tone for the trial. They help jurors understand the big picture before hearing detailed evidence. While the statements are not evidence themselves, they prepare jurors for the facts and witnesses they will see later. Your attorney will carefully plan your opening statement to present your side clearly and persuasively, without making promises or exaggerations. This is your first step toward influencing the jury's view of the case. Evidence presented. After opening statements, the trial moves to the evidence phase. This is when both sides present facts, documents, photos, or physical items to support their arguments. The prosecution presents its evidence first, trying to prove you committed the crime beyond a reasonable doubt. Evidence can include anything related to the case, like police reports, surveillance videos, or forensic results. The defense also has the right to present evidence to challenge the prosecution's claims or support your innocence. The judge decides what evidence is allowed in court and ensures it is relevant and legally obtained. Both sides can object if they believe evidence should be excluded. This phase is crucial because the jury will base their decision on the evidence they see and hear. Your lawyer will work hard to exclude unfair evidence and highlight weaknesses in the prosecution's case. Remember, evidence must prove every element of the crime, or the prosecution has not met its burden. This part of the trial can be complicated, but your attorney guides you through it step by step. Witness testimony. Witness testimony is one of the most important parts of a trial. After the evidence is introduced, both the prosecution and defense call witnesses to tell their side of the story. Witnesses can be police officers, experts, victims, or even people who were present during the incident. Their job is to share what they saw, heard, or know about the case. The prosecution goes first and calls witnesses to support their case. Each witness is questioned by the prosecutor in a process called direct examination. The defense then has a chance to question that witness in cross-examination. Cross-examination aims to find inconsistencies, bias, or reasons to doubt the witness's testimony. Your defense attorney will carefully prepare you if you are a witness and will also question prosecution witnesses to challenge their credibility or memory. It's important to answer honestly and clearly during testimony. Lying or stumbling can harm your case. Sometimes expert witnesses explain complex topics like forensics or psychology to help the jury understand the evidence. The defense can also call experts to provide alternative explanations or discredit prosecution experts. The judge may instruct the jury on how to consider witness testimony and warn them about relying on unreliable witnesses. The jury weighs all testimony together with the other evidence to decide what is true. Witness testimony can be emotional and tense, but it is your chance to help the jury understand the facts. Your attorney will guide you through this process to protect your rights and present the best defense possible. Closing arguments. After all the evidence and witness testimony, both sides make their closing arguments. This is the final chance for the prosecution and defense to speak directly to the jury before they begin deliberations. In closing arguments, lawyers summarize the key points of their case and explain why the jury should find in their favor. The prosecution will remind the jury of the evidence that proves guilt beyond a reasonable doubt. They will try to show how the facts fit together and why the defendant should be held responsible. The defense, on the other hand, will focus on creating doubt about the prosecution's case. They will point out any weaknesses or inconsistencies and argue that the evidence does not prove guilt. Closing arguments are persuasive speeches, not new evidence. Lawyers use this time to tell a clear, logical story that supports their side and appeals to the jury's sense of fairness. Your attorney will prepare carefully to make a strong closing argument that reinforces your innocence or highlights doubts. This step is critical because it helps shape how the jury views the entire trial before they decide your fate. Verdict and sentencing. After closing arguments, the jury begins deliberations. This means they meet privately to discuss the case and decide if you are guilty or not guilty based on the evidence and testimony they heard. The jury must usually agree unanimously to reach a verdict. If the jury finds you not guilty, you are immediately free to go, and the case is over. But if they find you guilty, the judge will schedule a sentencing hearing. Sentencing usually happens within 90 days of the verdict. At sentencing, the judge decides the punishment, which can range from fines and probation to jail or prison time, depending on the crime and other factors like your past record. The judge may also consider reports from probation officers or victim impact statements. If you disagree with the verdict or sentence, you have the right to appeal to a higher court. Your attorney can guide you through this process. Remember, a trial is serious, and the verdict will impact your future. Having a skilled attorney during the trial and sentencing can help protect your rights and work toward the best possible outcome. Don't forget to subscribe for more true legal insights. What part of the trial surprised you the most? Stay tuned for our next video. What are the possible punishments if you're found guilty?